Alrighty. Thank you all for coming today. I appreciate your interest in our signed ordinance and the changes that we have in front of us. Just going to jump right in here in terms of background and where these changes are coming from. There's a Supreme Court case that came out in June of last year called Reed versus Gilbert. It involved Gilbert, Arizona, and a church that had some temporary directional signs that it was putting up. And the town had different size standards for those temporary directional signs and what was allowed for political signs, things like that. So the enforcement officer there took action against the church's temporary signs. The guy whose signs were taken down appealed the decision. Through a number of other appeals, it made its way up to the Supreme Court. In the end, the court unanimously, 9-0, struck down content-based distinctions such as those that were employed in the town of Gilbert. Clarence Thomas wrote the majority opinion. He was joined by Justices Roberts, Scalia, Kennedy, Alito, and Sotomayor. Alito wrote a concurring opinion that becomes pretty important because he starts to lay out in there types of sign regulations that would still be permissible. Justice Breyer wrote a concurring opinion, and Justice Kagan wrote a concurring opinion, which Ginsburg and Breyer joined. And so basically, as we work through these different shaping opinions, Clarence Thomas really emphasized freedom of speech, talked about those distinctions that I just mentioned between those temporary directional signs and political signs. And he said that those types of distinctions should be subject to strict scrutiny. So not just any it's a higher standard to be applied towards ordinance analysis than just intermediate scrutiny or anything else. Basing sign regulations on the speaker and whether or not an event is occurring did not necessarily indicate that the regulation was content neutral. He said that you could regulate things like size, building materials, lighting, portability, moving parts. He said there may be a governmental interest that would survive strict scrutiny for public safety reasons, such as those regarding pedestrian or vehicular safety, so speed limit signs, things like that. There's a really compelling government interest in having those types of signs be distinguished. Justice Alito in his concurrence said, yeah, that's all well and good, but here are a few other things that I think would be okay in terms of government sign regulations: size, locations, lighting versus unlighted, regulations that distinguish between signs on private and public property, on-premise and off-premise signs with an asterisk, because how can you tell if a sign is on-premise or off-premise without looking at its content? Commercial versus non-commercial property, so basically having different distinctions between zoning districts and property uses. You could set a total number of signs per mile of roadway. You could put time restrictions on a one-time event. Again, a little bit debatable here because how can you tell whether or not a sign relates to a one-time event unless you're looking at its content? And then also whether you can regulate, you can make distinctions based on governmental speech, which are, again, speed limit signs, street signs, things of that nature. The Breyer concurrence, I'm going to sort of fly through these since not as many justices joined in these opinions as did in the majority. But Justice Breyer agreed with Kagan that content discrimination should not necessarily trigger strict scrutiny. It should be a bellwether for whether or not a rule is constitutional, and thus he concurred in the judgment only. Justice Kagan said that we should not subject content-based distinctions to strict scrutiny. She expressed concerns about the Supreme Court becoming the Supreme Board of Sign Review, and she also concurred in the judgment only. So this is the background from the case in June that sort of landed us where we are now, which is reviewing our time signed ordinance and looking at ways to make it content neutral pretty much through and through. So what does it mean for us? Going to go a little bit deeper into the specifics. Previously, our sign ordinance had many content-based distinctions. We had rules that applied to political signs. We had rules that applied to real estate signs. We had rules that applied to open house signs, construction signs, subdivision signs. Now we're content neutral. Our distinctions are based on zoning district, whether or not a sign is located on the municipal right-of-way or on your private property. Previously, we had some content dictated. Such signs may only show X, Y, or Z, so we said you can only show the developer or the builder, and the address and the phone number. Those were the only things that you could put on signs, so we got rid of that content dictation. So any place where we had specifically said you must have a particular message on this sign, that's been removed. The basic principles that sort of underlay this rewrite of our sign ordinance were content neutrality, which I've stressed now throughout this presentation. Preserving our existing signage abilities. So people currently use signs for a lot of purposes. We see them for properties being for sale. We see them for identification of our businesses. In this rewrite, we didn't want to limit those uses any more than necessary. We're making progress towards our UDO. We currently have a separate sign chapter. This would wrap it into the zoning chapter. We've treated it like a zoning chapter because we do have different distinctions in our sign ordinance between different zoning districts. We also wanted to keep the administrative burden minimal. So right now, people can put up real estate signs and yard sale signs and open house signs without necessarily having to come to us for a permit. And we didn't necessarily want to get in the business of having someone come to us every time they needed a real estate sign, or setting a time limit on those types of signs where they had to come back for renewal every 7 months or something along those lines. That's just a lot of paperwork on our end, and we were trying to make this as easy to administer as possible. The committee was Kathy Worley, Ike Pipkin, and Bud Daniels from the Planning Board, and then former Commissioner Bob Danahy and Commissioner Broadman served on this committee after the election in November. We met from October to March in drafting this ordinance, ran it through the attorney. The Planning Board has seen it and recommended it to the Board of Commissioners for adoption. Last month, they adopted the consistency and reasonableness statement to go along with it. The Board of Commissioners saw this ordinance at their April meeting, April 13th, and they will see it again next Wednesday, May 11th at 6 o'clock. And I'll be requesting that they call for a public hearing on the ordinance at that time. Presumably that public hearing would be in June, at which time they could also consider the ordinance. So that's sort of where we are in terms of the timeline of adoption. So for the sake of our ordinance, working through what is a sign, and for those of you who have the handouts, this is on the very first page. It means and includes any device, the message of which is visible from any street, right-of-way, public beach, or adjacent property within the town, including but not limited to placards, billboards, handbills, balloons, flags, banners, or any other things or instrumentalities used for the purpose of conveying a message or idea or gaining attention. This is a pretty broad definition of signs. You'll see it's pretty all-encompassing. This is the same definition of a sign that we've had. This is not a change with the new ordinance. So to move a little deeper into the specifics of this ordinance in terms of general sign guidelines, it's now section 74-221, which would be on the second page of your handout. It's a general carryover from our previous section 62-4. With the addition of signs during construction for non-residential zoning districts, and the section that was formerly temporary signs has been removed due to content requirements. We also generally allowed all governmentally erected signs. Went through on this slide some of the retentions and removals for this ordinance, and so you can see what's changed versus what hasn't changed. We retained language that said that no sign shall be erected, located, or maintained so as to prevent free ingress to and egress from any door, window, or fire escape. Public safety mentality that would drive that section. All signs shall be firmly and securely attached to either the ground or structure. All signs shall be, oh, that's the same, okay. No sign other than those permitted by section 62-7 shall be permitted which does not relate directly to the premises upon which said sign is located. That was the on-premise, off-premise distinction. That's been removed. because we determined it was a content-based distinction. No sign shall be lettered, outlined, or otherwise decorated with any reflecting paint, beads, or prisms unless erected by a governmental agency. Lighting shall be for purposes of illumination only. Flashing lights being prohibited. Lighting shall not be allowed in the line of vision of vehicular traffic. That section's retained word for word. No signs such as those with red and or blue lettering or images that may be confused with an emergency vehicle should be allowed within the town. That language was also retained. Some of the changes in this section. We said that no sign shall be replaced on any municipal street right-of-way unless erected by a governmental agency approved by the town manager or is allowed by subsection 62.5.8 C, D, and E. That language is generally picked up in the first sentence of the new language. No sign shall be replaced on any municipal street right-of-way unless erected by a governmental agency approved by the town manager or is specifically allowable in this chapter. We noted that governmentally erected signs are permitted along all town and state rights-of-way within the town, as well as on town and state property if approved by the town manager or his designee. We had a slight change in the language of no sign shall be painted directly on the wall, side, or structural part of any building, tank, fence, wall, or other structure not erected specifically as a signboard. Except for town identification on municipal water tanks. The only change here is that instead of municipal water tanks, we now said on municipal property. We used to say that all signs shall be built of a non-corrosive material and of wood shall be treated to inhibit decay and shall be built of durable material. Now we just note that all signs shall be built of a non-corrosive durable material. Some of the additions that we've seen in this chapter. We used to have a separate section that related to construction signs, and this is one of those areas that I noted where we had specific content that had to be on these signs. And those content guidelines are gone. We added it to the general sign guidelines section because it applies to multiple zoning districts. As long as it's non-residential, these signs can't exceed 50 square feet, which is consistent with our prior language. And we did have some time limits, couldn't be put up more than 30 days prior to the commencement of construction and had to be removed upon the issuance of a certificate of occupancy. Again, no content distinctions there, but some time frameworks. We had flags if flown for non-commercial purposes on private property. They were included in signs not requiring a permit. We did add a 15 square foot limit here, which has proved a little controversial. Some CAC members raised the fact that some people have 6x4 American flags on their property. I alerted the planning board to this at their meeting. The committee members who were there generally supported the 15 square foot language. However, I'm going to bring this to the Board of Commissioners' attention also and see what their will is as this ordinance goes forward to public hearing, to see if they're interested in keeping the 15 square foot limit or want to change it to something else. We said that unless expressly permitted by this chapter or by state law for state road rights-of-way, no sign shall be allowed within the town. It used to be its own section. Now it's just been moved into this general sign guidelines section. And I know the text is really small up on the screen, but I'm trying to work through it sort of illustratively. The next section to talk about are signs not requiring a permit. This is now section 74.222, which starts at the bottom of the second page of your handouts. It generally followed what was section 62-7. But there is some nuance. Again, the size limit of 15 square feet on a flag on residential property. We noted that governmentally erected signs on private property do not require a permit. These would be things like a rezoning notice or a notice of hearing if someone were applying or appealing a zoning decision or asking for a variance, things of that nature. Those are generally when those signs would be put up. There's a general allowance for 3 square foot signs on private property. Visible from the road and having a cumulative area less than 9 square feet. Section 74.222-6, I'm going to, parentheses 6, I'm going to go into a little more detail on this in just a second. This deals with temporary signs in the town right-of-way. We imposed a 4 square foot limit, no content guidelines, no taller than 3 feet, couldn't obscure visibility, needed to be oriented parallel to the street, needs to be set back 12 feet from the paved surface of the road, but no closer than 6. We had some old language that dealt with vegetated areas that were next to the street that would obscure a sign in that 12-foot range. And so if there was vegetation, you had to be at least 2 feet from the edge of the vegetation, but in no event could you be closer than 6 feet from the edge of the road. These signs can't be permanently installed, and they are subject to permission from the adjoining property owner. So if it's in the town right-of-way, you'd be looking at the property that's adjacent to that portion of the town right-of-way, or adjoining that portion of the town right-of-way.
You want us to ask questions later?
I'll go ahead and take them.
Well, I was thinking about yard sale signs in
Mhm.
that case. So, under the new ordinance,
Mm-hmm.
this is where that comes
Correct.
into play.
Correct. So you'd want to. We used to have language that yard sale signs could only be placed at street corners where turns were necessary to get to the yard sale location. Now you'd basically go to the adjoining property owners for where you'd like to put your yard sale sign, request that you use their 4 square foot sign allocation to put your sign in their portion of the right of way, or not their portion, but in the portion of the right of way in front of their home. That's how we would be interpreting it. Oops. In terms of sign, another emphasis on signs not requiring a permit, we were allowing non-governmentally erected signs at the town's designated voting site, which is here, subject to a 3 square foot limit, needing to be removed by 8 a.m. the morning after voting day, no closer than 3 feet from a paved surface, and a minimum of 5 feet between signs. And subject to any other state elections laws regarding sign placement. So this is another comparison slide, and I'm happy to share this with y'all if you'll leave me with your email addresses if you want copies of this presentation. So again, signs not requiring a permit. The old language for flags if flown for non-commercial purposes on private property. Now flags on residential property not exceeding 15 square feet. Legal notices, identification information, or directional signs erected or required by governmental bodies which do not exceed 3 square feet. This is again the governmentally erected signs on private property. We specify that they won't count against the 9 square foot limit for signs on private property. We retained language that related to integral decorative or architectural features of buildings, not including letters, trademarks, moving lights, or moving parts. And then we used to allow identification, information, or directional signs not exceeding 3 square feet in area, constructed by a homeowners association and which are located on premises owned by the homeowners association or subject to their jurisdiction, which relates directly to the premise. Now we just allow 3 square foot sign, and again, I need to clarify, there's sort of a hierarchy here. Signs not exceeding 3 square feet in area constructed by the homeowners association, which are located on the premises, are not required to get a permit. Signs on those properties are allowed up to 8 square feet in size, but between 3 square feet and 8 square feet, they would require a permit. That's the distinction here. Just didn't want anyone with a homeowners association to think that y'all were limited to a sign that was 3 square feet in size. You're actually allowed up to 8, but with a permit. Again, so we used to have subject to election laws on placement political signs not exceeding 3 square feet. These are now the non-governmentally erected signs at the town's designated voting site that I talked with you about just a few minutes ago, and the associated rules. We used to have a provision specifically for off-site tourist-oriented directional signs on state-maintained rights-of-way. These would be the signs that you see for the Atlantis Lodge and the Country Club along Highway 58. Now they're covered under our general allowance for governmental signs, to the extent that we have any authority on state rights-of-way anyway. Town identification signs on municipal water tanks, again, now they're covered under that general allowance for municipal signs on municipal property, or governmental signs on municipal property. So these are all the types of signs that were allowed, that didn't require a permit less than 3 square feet in size before, and the language that we have now. So we used to have signs not exceeding 3 square feet in area, bearing property numbers, post office box numbers, names of occupants of premise, or other identification, not having any commercial connotation. We do, in essence, still require that. We require at least one sign identifying street address for all properties which have a dwelling unit or other substantial development. For new construction, we're holding up the certificate of occupancy until a sign like that is in place. We did feel that this was a particular content-based distinction that does have a pretty compelling governmental interest for emergency vehicles and emergency response. So that's why we do still have this particular content-based distinction in here. They're not subject to the 9 square foot limit for other residential signs. We used to have identification signs denoting the architect, engineer, or contractor when placed upon work under construction, not exceeding 3 square feet in size. They said that those signs had to be removed prior to the issuance of a certificate of occupancy for the completed construction. That specific allowance is no longer in there. It's just you're allowed to have 3 square foot signs on your property. All the signs can't exceed 9 square feet. And other examples: parking, entrance, exit, private property, no trespassing, and those types of signs. And signs on private property with exclusively political or religious messages subject to the following: 3 square feet in area. Cumulative area of all such signs on the zoning lot shall not exceed 9 square feet. So we basically took that last requirement for signs on private property and just made it universal no matter what the content of those signs is.
Can't say that.
Yeah, this one gets pretty small pretty quick. And this deals with things that used to be basically in the town right-of-way. These are our real estate signs, our open house signs, and our yard sale signs. And we created one giant new section on the right that establishes the standards for all of them. We made everything subject to a 4 square foot limit. And again, the 12 feet from the paved surface of the road, unless it puts the sign in a wooded area. I mentioned those restrictions earlier. You can go 2 feet from the wooded area, but no closer than 6 feet. And this is where we have the language about getting permission from the adjacent property owner with regard to putting those signs up. The top of the sign can't exceed 3 feet from grade. And again, many of the things I've already worked through: temporary signs not impairing vehicular visibility, oriented parallel to the street, must be of professional quality and easily removable, not permanently installed in the street right-of-way, and not allowed to be placed on a utility pole or pedestal. So those, I've really tailored this mostly to our residential guidelines, figuring that would be most of the areas of interest for the town. Articles 2D through 2K of the handouts deal with zoning district specific regulations. Sometimes we had options for a larger sign size if a directory was involved. In each of those cases, we opted towards the larger size, which was 60 square feet instead of 50 square feet. Most of the impact there would be on commercial properties. We met with the Trinity Center, Pikesco, and PKA about the revisions to at least give them a heads up in terms of the direction we were thinking about heading. And for commercial signs, there were some separate regulations that dealt with commercial signs that we wrapped into this section instead of leaving isolated elsewhere in the zoning chapter. Regarding any language on sign permits, enforcement, and nonconformity, there's no language change there. The procedures are all the same. It's carry forward of language from 62-6 through 62-9 in our existing Code of Ordinances. Those are going to be starting Articles 2L, 2M, 2N, and 2O from your handouts, which I'll let you review at your leisure. We talked about commercial signage in residential zoning districts. We didn't incorporate any distinction based on concerns about being able to distinguish between allowing people to maintain real estate for sale signs, for rent signs. We didn't incorporate a specific prohibition on offensive language. We're really hoping that people will be reasonable with the sign ordinance and not abuse the flexibility that's been incorporated in it. We can, it's sort of we took the approach when we were writing this as sort of an all or nothing sort of approach. Do we allow a sign in the right of way? Do we not allow a sign in the right of way? We opted in this ordinance language to allow signs in the right of way, and we set restrictions on them, again, based on what people are allowed to have right now. But if we start to run into problems, we can go back and revisit this ordinance at a later date if things become ridiculous or out of control. In case you were wondering, the Supreme Court case does not impact enforceability of homeowners association covenants. So it is possible that more enforcement actions will fall back on the homeowners associations. That's up to them and their own enforcement practices. Our ordinance focuses on municipal street rights of way. Our presumption is that we're largely preempted on state road rights of way. There have been some specific laws that have come out in the past couple of years, specifically regarding political signs from the state. And so the state has a couple of things that they need to figure out with regard to their own laws also. A couple of HOA covenants of note. PKA says that no sign or billboard of any kind shall be erected or allowed on any lot other than one for sale or for rent, not larger than 3 square feet. For sale and for rent signs must be freestanding and not attached to a dwelling or to a tree. Small signs not exceeding 3 square feet displaying owner's name or the property name are also permitted. Pikesco said no sign or billboard of any kind shall be erected or allowed to remain on any lot other than a for sale or for rent sign, not larger than 2 square feet in size. Additionally, the sign restriction shall conform to the Town of Pine Knoll Shores ordinance on the use of temporary signs on private property. Beacons Reach says that no signs are permitted without the approval of the Architectural Control Committee. The only permitted signs are for the purpose of identification and not advertising. Signs identifying home security providers will be permitted upon approval of the committee. Furthermore, no advertising devices such as figures, lights, colors, or architectural styles intended to attract the public shall be allowed. The committee shall consider location, size, material, lighting, and color when considering the application for approval of a sign. The committee may allow temporary promotional signs during construction on any parcel. Notwithstanding the provision of this section, the owner of any single-family living unit may, without permit or permission, attach to his unit a sign not to exceed 3 square feet, identifying the owner of the unit and the address of the unit. Their single-family bylaws say that no for rent or similar signs shall be allowed on any lot or be placed so as to be visible from any public or private street. They permit only one for sale sign to be erected on any lot. No for sale sign shall be allowed unless said sign is of a size no greater than 3 square feet in size and is constructed totally of wood, with all lettering thereon sandblasted or carved, in each case to a professional quality, and all painting on such signs shall also be done to a professional quality. No sign shall be permitted on which the lettering is not either sandblasted or carved. No such sign shall remain on any lot or shall be placed so as to be visible from any public or private street prior to a valid and binding listing agreement being signed with the broker, placing said sign on the lot unless the sign reads for sale by owner, and any such sign must be removed within 3 business days following the final closing on the sale of the property upon which such sign is located. So pretty much all of these homeowners association covenants are more restrictive than what we're proposing in this revised sign ordinance. And that's just something for your residents to be aware of as they're considering their signage. Yes, sir.
Scott, if the homeowners association can have a more restrictive rule than the town, but it can't really have a less restrictive rule, because then the supremacy of the town comes into effect.
Right, they can. It's just who does the enforcing at which point.
Right.
So when the homeowners association is more stringent, they would be the ones enforcing it. If our rule is more restringent, we would essentially be the ones enforcing it.
Does this sign ordinance also prohibit graffiti?
No,
No, just have a rule for that?
no, it does not.
Really?
Really.
If somebody were to come up to the Mimosa Bridge and write,
Yeah, I'd have to check under our general penalties provision to see if there's something there. It's possible that we would have a prohibition there, but not in the sign ordinance specifically.
Assuming that all of this refers to signs from the front of any house or sign, any street frontage, what if a 4x6 flag were on the back of it?
That question came up at the CAC meeting, actually last month. And I looked into it a little further. Unfortunately, our definition of sign includes signs that are visible from adjacent properties. And so that's what really triggers our restriction on those.
you know, these cute little signs people put out there, like clean up after your dog. and things like
Yeah,
that. They're small, I mean, usually, and
yeah.
they're inconspicuous kind
Yeah, as long as they're less than 3 square feet in size and the cumulative area does not exceed 9 square feet, they should be on private property, not in the town's right of way. I should stress that. Any other questions? Well, thank you all for coming. I appreciate it. I'm glad that there's some interest in this topic as it moves through the approval process. And if you have any feedback or anything, I'm happy to pass it along to the Board of Commissioners. But otherwise, thank you.
Thank
Okay. I guess I have time to get my yard system and the freezers. We bag them in regular, we put the little individual bags in fresh.
Alrighty. Thank you all for coming today. I appreciate your interest in our signed ordinance and the changes that we have in front of us. Just going to jump right in here in terms of background and where these changes are coming from. There's a Supreme Court case that came out in June of last year called Reed versus Gilbert. It involved Gilbert, Arizona, and a church that had some temporary directional signs that it was putting up. And the town had different size standards for those temporary directional signs and what was allowed for political signs, things like that. So the enforcement officer there took action against the church's temporary signs. The guy whose signs were taken down appealed the decision. Through a number of other appeals, it made its way up to the Supreme Court. In the end, the court unanimously, 9-0, struck down content-based distinctions such as those that were employed in the town of Gilbert. Clarence Thomas wrote the majority opinion. He was joined by Justices Roberts, Scalia, Kennedy, Alito, and Sotomayor. Alito wrote a concurring opinion that becomes pretty important because he starts to lay out in there types of sign regulations that would still be permissible. Justice Breyer wrote a concurring opinion, and Justice Kagan wrote a concurring opinion, which Ginsburg and Breyer joined. And